Barkley. I am one of the staff attorneys with the Michigan Department of Civil Rights. So welcome. It is my honor to welcome you. We have some very interesting and informational session here for you on disparate impacts of housing discrimination and effective investigation strategies. While we wish there was no bias in the world, that is not the reality. And so that's why discrimination investigations are necessary and the best way to uncover systematic discrimination in housing. So we have worked really hard to assemble this fantastic, very experienced, wealth of knowledge and informative panel for you that is going to talk a little bit about the processes and realities of disparate impacts. So join me in welcoming our panelists. We have with us Steve Tomkowiak. He's in the middle here. He's got decades of experience, is the executive director of the Fair Housing Center of Metropolitan Detroit, experienced trial attorney, and national fair housing trainer. We have to my left, and so maybe to your right, Becky Nesbittall. She, with her extensive social work background and work in public service, she is the current enforcement coordinator with the Fair Housing Center of West Michigan and represents that organization within various and quite a few advocacy groups over there on the west side of the state. And then finally, far over there, we have Sol Kim with us, who is a wonderfully experienced trial attorney at the U.S. Department of Housing and Urban Development, aka HUD. So then Sol has worked on many discrimination cases over the past couple decades. So welcome to our panelists. I don't want to take a whole heck of a lot of time reading their majorly long and wonderful bios, which you can find in the Whova app or by scanning that QR code that you see floating around everywhere. So, before we begin, a few ground rules. This is about fair housing, not just housing, so we're going to focus on bias, discrimination, and disparate impacts. For example, things of like when buying or renting a home or obtaining credit ratings and mortgages. So just like you've heard in other sessions, we'd like to see a couple policy recommendations if possible that can advance fair housing as we move forward. We welcome comments with potential solutions for the issues discussed. And keeping in that kind of same frame of mind, please keep any discussions focused on the topics. We are currently unable to address any of your individual complaints or circumstances. And then finally, please keep all conduct and comments to be pretty appropriate. We're not going to tolerate anything that's inappropriate or inflammatory, disrespectful, anything like that. You'll be given one warning, and I used to work in a prison, so I'm not afraid to tell you about yourself, and then you'll be asked to leave. So, without further ado, we are going to get started with Steve Tomkowiak, and we're going to hear about evictions from Steve. This one seems to be working wonderfully. Yeah.
This is a disparate impact panel. We're going to be talking about disparate impact, but we'll be dealing at various topics of disparate impact. And I don't know what happened here. I'm going to be dealing with disparate impact in the context of evictions. How big a problem are evictions? And what can disparate impact do to address it? Those are the two questions. And we are not doing real well. First off, defining, right? Let me pull this up here, sorry about that. There's area median income, extremely low income, middle income, and so forth. But extremely low income are families with households at 30% of AMI, at or below 30% AMI. And that's kind of our, and here are characteristics, well, I have it here. Nationally, right? Two other things is cost burden are families that spend more than 30% of their income on housing. Severe cost burden are families that spend more than 50% on housing. I'm not a big fan of percentages because as you get to lower income levels, even 30% is too high. 50% at a low income level is just too much. To kind of put it in context, a family, say, I don't know, their income is $1 million a year, something extravagant, right? If they go up to 90% of their money on housing expenses, that still leaves what? $100,000 in disposable income. So it doesn't matter at the higher income levels, they can spend any amount they want on housing and they're still fine. At the lower income levels, it's much worse than that. But studies have shown consistently that there's a couple thresholds. One is 22%, where eviction rates start happening. It gets higher at 30%, at 50%. They're living basically on the edge of eviction. Added to this, we have a affordable housing shortage. ELI, extremely low-income households, are 1/4 or 11 million families of the nation's 44.1 million renter households, but there's only 7 million households, affordable rental units available for them, so it's a shortage of 4.0 million affordable housing income. So what does it tell you? That's the only income level where there's a lack of affordable housing. In Michigan, the data is 36 affordable housing units for every 100 ELI families. For all other income groups, there is sufficient numbers. So what do we find on the eviction filing rates? Nationally, it's 1 in 12 or 1 in 12.82 households or 1 in 13 households. In Michigan, the eviction filing rate is 1 in 7.8, nationally. That's approximately 7.8 of households. In Michigan, 1 in every 6.25 households, or approximately 16%. Some years it goes even higher, 17% or 18%. And I've seen nationally sometimes it goes down to around 6%. So we're 2 to 3 times higher eviction filing rates in Michigan. And some people think, well, what's wrong with these families? Or maybe they put themselves in this situation. When it comes to extremely low-income households, 35% are employed. Of the 35% who are employed in the workforce, 39% work 40-plus hours a week, 30% work 30 to 20 to 39% hours a week, 11% work less than 20 hours a week, and 20% are unemployed. They're working, but they don't make enough money. 30% are seniors. Their income is pretty much fixed. 18% are disabled. 4% in school, 3% single, and 11% others. So basically, it's not a large group of people. I'm sure everybody bears some responsibility for situations they're in their life. But to take the idea that they're families that made really bad decisions, bad housing decisions, things of that nature, would not be accurate. I stopped asking people, why did you go into a place when the repairs weren't done? I'm not a fast learner, but I started to realize there's nothing else available, and that's why they did it. No one goes into a place under a promise that the landlord is going to do repairs, and they don't, but they're just desperate, right? People are desperate to stay in housing because what? There's nothing else available. Eviction filing rates by county, this was the Michigan evictions data from a report from May 2020, covered a 5-year period. Genesee County, 27%. Now this is 27% of the families per year had eviction cases filing. It's stunning. Macomb County, 24.4, Wayne County, 22.6, Monroe County, 22.6 as well, Calhoun County, 21.6, Oakland County, 19%. Within large cities, it's not just a Detroit problem, some people think. Romulus, 47%, Inkster, 39.8%, Taylor, 37%, Southfield, 32%. You get the idea. We did an analysis of impediments for Clinton Township. The data there was around between 30 and 35%. Difficult to get the actual numbers because Clinton Township is combined with Mount Clemens, but the court administrator had an idea like how many, on average, how many complaints are filed out of Mount Clemens as opposed to Clinton Township, and could kind of extrapolate the numbers. You wouldn't think of Clinton Township as the 10th largest municipality having a high eviction rate, but it's very high. Now, what underlies this often is civil rights violations. The Michigan 2020 study kind of jumped out. Within urban areas, variables that had a statistically significant correlation with evictions had a 95% or above statistical significance level, were families headed by African American families, single mothers, and families with children. For 504 compliance, I don't have the charts in that, but they're very, very ugly. just dealing with race, black renters face a disproportionate burden. White renters' fair share of renters are 36%, but only 30% of the evictions. Black population is 31% of renters, which tells you, obviously, there's a gap in home ownership, which underlies this. Share of defendants are 49%. When it comes to women, fully 60% of the eviction filing rates last year were against women or families headed by women households. And the real disturbing thing as well, the impact on children across every group. For white families with no children present, the eviction rate was 2.6%. If they had children under 18% in the home, 6.2%. Almost triple. For black families, it goes from 16.1%, getting higher filing generally, but if they have children, 26.7%. Over a quarter of the families, right, black head of household families with children face evictions. What did the children do to get this? Hispanic, no children present, 4%. Children under 18 present, 6.5%. And I don't have the chart here, but the chart actually shows that it actually, at the younger age of the children, the more likely the family is to face eviction. So even the most vulnerable, youngest ones, like 0 to 6, or just that it gets bad all the way up. The more eviction filings occur when there's children in the household. Now there'd be a lot of factors for it or whatever, but it's still. And you think about the implications of it. What does it do for health, education, all of those things when we're moving our children from home to home to home? Again, and underlying it too, right? Lack of habitability and all the other factors that go there. There's HUD report, also positive 2021, called it a scarlet E. Eviction can be the equivalent of a prison record. Evictions carry a stigma. Many landlords will not rent to persons who have been evicted, and eviction can also ban a person from affordable housing programs, right? Not only you lose your home, you risk what? You losing your possessions, stripped of assets. Then they have to move from one undesirable location to another. The phenomenon of scarlet E is so harmful and damage. It's a legal record that no matter the outcome of the case, even if a tenant wins, it's still searchable for a long period of time. That's so true. And there's also a constitutional violation, because if you want to contest habitability or have a claim against a landlord heard in court and it results in an eviction filing, it counts against you. That's discouraging you from exercising your First Amendment right to present claims in court. That was a conference. I've got some group that does a lot of research in that, and they're talking about all the ways to challenge eviction. I said, what about the due process argument, First Amendment issue, Constitution issue? Well, yeah, that is a really major one that we could raise and should be raised. All right. So common eviction cases that mask underlying fair housing case, I just have some of the listing. There could be a non-renewal of tenancy. They're inherently suspect. Nobody evict somebody for no reason. It's a fiction. There is a reason. Oh, we're going to sell the home at a reasonable accommodation. Oh, I'm going to sell my home. Of course, the guy still hasn't sold the home. It's been a year and a half. And the tenant who had asked for reasonable accommodation is long gone, and now somebody else is living in the home. He owed 10 properties in Madison Heights. Why did he pick that one home to supposedly sell? Suspect. Court did not accept the merits of that case. Yeah, it's ridiculous. But non-renewals are very, very suspect. Wisdom, Ann Arbor, and other places require people to be honest in why you're evicting somebody, right? Non-renewals are very suspect. Evictions for one or more rule violations, quid pro quo, sexual harassment, domestic violence, emotional support, service animals, assistance animals, limitation on the number of occupants, denying occupants due to eviction history, citizenship status, targeting disabled and other minority groups, overly restrictive criminal record policies. A lot of fair housing violations underlie eviction. when I first started, I mean, Mike Ocean was a legal service coordinator. I said, well, eviction cases, they must be really, really tough because, people probably did something bad and that's why they got evicted. He goes, no, Steve, eviction cases actually are our best cases. It took a while and I started to learn, yeah, he's right. Because that's the worst thing you can do to somebody. Same way in employment situation, the termination cases are probably the best cases. You've actually gone, you put a family out of their home is a serious thing, right? So there's a need, if we can bring fair housing to the table to address this. In terms of disparate impact, I posted a question, and Tim Moran goes, well, that sounds like it's a very landlord or very housing provider type question. Like, why is disparate impact seems really unfair because you're targeting people or saying people are liable for discrimination when they didn't intend to do anything wrong. I intend to discriminate, and you're bringing disparate impact where you don't even have to prove it simply because there's discriminatory effects. Yes, that is the law and is there for a reason. The Supreme Court in Inclusive Communities, Justice Kennedy, writing for the majority, upholding disparate impact theory of liability under the Fair Housing Act said, results-oriented language is in the Fair Housing Act, 576 U.S. at 534. It's looking at the results. He also has this point, which is real clear. Recognition of disparate impact liability under the Fair Housing Act also plays a role in uncovering discriminatory intent. It puts plaintiffs, it permits plaintiffs to contest unconscious privileges and disguise animus that escape easy classification as disparate treatment. Ultimately, really, is it really intent we're concerned about or the implications of a housing decision? Really, it's the latter. It really is. By nature, disparate impact is broad and systemic. It will affect a group of people. The biggest cases are disparate impact cases. If I was going to die on certain battles, I would die at two, right? Disparate impact, and the other one I would fight would be affirmatively furthering fair housing, because those are two things that can get more at the problem of segregation than anything else. Most people think, oh, the Fair Housing Act is designed to stop segregation. It doesn't. The only things that get at it really are disparate impact and affirmatively furthering fair housing. Nothing else does. Implicitly, the theory is by stopping discrimination, we'll address the problem of segregation, but it doesn't do it directly, and at 55 plus years, it has not been effective. Our community, southeastern Michigan, is number 3 in terms of nationwide in terms of segregation. We're number 1 in terms of racial isolation, believe it or not. So it hasn't really worked. I have those slides on the background of disparate impact under the Fair Housing Act. Congress debated fair housing legislation, passed it in 1968. From 1968 to 2012, no Supreme Court decision under the Fair Housing Act dealing with disparate impact theory of liability. 1968, Kerner Commission, America going to two societies, separate and unequal. April 68, Dr. King was assassinated. Then it got passed. Then in February 2013, HUD promulgated its 2013 disparate impact regulation just before, the Supreme Court was going to, there were a couple appeals filed. I think it looked like HUD was concerned that it didn't have anything formal on the record when disparate impact was going to get reviewed by the Supreme Court. If you look in the footnotes in Inclusive Communities, you're going to see there was some playing around to convince cert petitions to be dismissed because they didn't want it reviewed. But nonetheless, in Inclusive Communities, Justice Kennedy, writing for the majority, approved disparate impact theory of liability under the Fair Housing Act. HUD on October 26 did an application of disparate impact theory to insurance. In 2020, HUD, everybody regulates, no matter what persuasion people are. They all regulate. They don't admit it, but they all regulate. September 2020 was a massive amount of regulation to basically regulate disparate impact out of existence. It didn't work. That was enjoined. And then in June 2021, HUD kind of went back to reinstate its 2023 regulation, and that's where we're at. That got finalized in March 2023. Very unusual to have an agency, any federal administrative agency, have a disparate impact rule, the 2013 rule upheld by the Supreme Court implicitly, and then revisit it. It's like never happens. But they don't like it. Disparate impact is not popular. In Michigan's civil rights laws were passed in 1976. Disparate impact was recognized in a non-fair housing context in 1984. But from 76 to the present, no cases. Rare exception, it was brought in a Michigan Civil Rights Commission case, but this disparate impact claim was dismissed. That was March 2014. That's been it, so it's overlooked, not used. Real quick, HUD's disparate impact rule has a three-part burden. Unfortunately, the first part's called the prima facie, because it gets confused with disparate treatment, but I just call it the first element. 2 parts, actually or predictably results in a disparate impact on a group of persons, or 2, creates, increases, reinforces, or perpetuates segregated housing patterns because of race, color, religion, other protected class categories. That second part, sub I, 2I, is so important, should never be overlooked. There is no counterpart in employment. This is unique to housing. I wouldn't mind it in housing or employment, but it's not there. It often gets overlooked in cases. I'm going to come back to it in a second. Then once that's shown, the defendant then has a burden to show legally sufficient justification. It's not a business justification like you see in employment cases, because it's not necessarily always a business type situation with housing. But defendant must show it's necessary to achieve one or more substantial, legitimate, non-discriminatory interests, and it must be supported by evidence and can't be hypothetical or speculative. Then if that's met by the defendant, then the plaintiff then has a burden to show the alternative practice could be adopted that achieves the legitimate interest without the same kind of disparate impact or less discriminatory effect. Supreme Court Inclusive Communities came up with safeguards. I think it's dicta, but it's being followed. The Supreme Court in Inclusive Communities granted cert on 2 questions. There were 2 questions raised. Should disparate impact be recognized under the Fair Housing Act? And number 2, what should the standard be? They granted cert only on the first question, yet it's cited for guidance on the second, which is not correct. It's pure dicta in terms of what they articulated as these safeguards. And so here's what he says. Kennedy said that it's necessary, adequate safeguards, numerical quotas do not automatically give rise to liability. That could raise a constitutional question. And he emphasized the causal connection requirement. I'm going to go detail to save time. He also said that there is a robust causality requirement, and the policies won't give rise to disparate impact liability unless they create artificial, arbitrary, and unnecessary barriers. So what you have is the standard is an interplay between the Supreme Court's ICP standard and HUD's disparate impact rule. So it's basically a 3-part burden shifting approach. Step 1 is the plaintiff has to show, right, a specific policy, significant adverse and disproportionate effect that creates, increases, or reinforces or perpetuates segregation housing patterns, and causality, that the challenge practice rather than some other factor caused the disproportionate effect. So that's the standard of it. Here's where the problem comes in with the robust causality department. The ICP wrote racial imbalance alone doesn't establish a case of disparate impact. And here's where the real play comes in. Most courts find robust causality established if there's statistical evidence presented showing that a protected class is disproportionately impacted by the challenge policy. However, Lincoln Properties and other courts take it a step further and say, no, not only to show that the policy had a disproportionate effect or impact, but that the challenge policy caused the racial disparity. If that standard gets imposed, pretty much the complainant has lost. It's that difficult of a standard, right? That's where really the challenge lies. The second one is okay in terms of showing that the challenge, well, for a housing provider to show is necessary to achieve one or more substantial, legitimate, non-discriminatory interest, to always come up with that, right? On the third part, it's requiring the plaintiff to show defendant's interest could be served by an alternative practice that has a less discriminatory impact or effect, right? And so that's pretty well established, but the real battle is on that first element. Now I'm gonna, how much? Okay. Go real quick, 2 quick case studies. One is Legal Aid of Chicago versus Hunter Properties. This is just dealing with disparate impact in the context of eviction. The housing provider, this was challenged under race and sex, violation of the Fair Housing Act. They managed 2,500 rental units. They deterred people with evictions from filing, asking them if they've ever been evicted. No indication they ever excluded sealed eviction records. They didn't provide applicants with an opportunity to explain any detail regarding their eviction case. They charged a $70 rental fee and so forth. And they required the current landlord's information or prior landlord's information so they could dig up information about prior evictions. And so what happened, the housing provider also used a screening device to identify and screen based on prior evictions. They had a blanket no eviction policy, period. Any eviction policy at all results in denial. Statistical evidence showed that black individuals from September 2010 to March 23 constituted 33% of all renters in the community, but 56% of the persons served with an eviction case or evicted. Women were 1/5 of the renters, but account for 33% of all persons served with an eviction case or evicted. So what happened there is what? It had a profound, right, statistically significant effect based on race and sex. And they found causality, that it was discouraging people from applying. Was there, step 2, was there, and they relied, importantly, right, they relied on HUD guidance with, when it comes under Title VI, with Civil Rights Act and marketing and application processing at subsidized multifamily properties, dealing with screening criteria to make sure that it wasn't overbroad. So what was the one or more substantial, legitimate, non-discriminatory interest? What did they say? Basically, the complaint said that there wasn't any. That was their argument. They also relied on guidance from the CFPB. Again, on any disparate impact case, you must buttress it with research, reports, anything. If you just come up with the statistics, of course, they're probably not going to say that's enough. Sad to say, you've got to buttress it. Can't just be your statistical argument. So that was basically it, and that was how they felt that they could establish it. The problem with this would work in most situations, except if they require proof under the more difficult step 1 approach that the policy caused the imbalance, right? Then it's very difficult to show because the area already had a problem in terms of the community. The better one is the second case. Are we flipping it? It's Hope Fair Housing Center versus Oak Park Apartments. Had the same kind of policy. It applied to application requirement. It basically said in the application, you cannot have a bankruptcy, judgment, eviction, foreclosure, history of late rent or payments, or short sale. The policy applies to all applicants over the age of 18. And they would do the same thing. They'd contact past landlords. They also would use third-party screening to look for prior eviction filings. So what happened is what? Again, they cited the same kind of reports from the CFPB and the FTC dealing with the problem of eviction records and screening devices, that the impact that that could have on people based on race and sex. Typically, black women and blacks generally. Again, buttress the statistics with reports and policy statements. Then the housing provider also did not define eviction. So they followed this up with testing evidence. They had a black female tester with a good rental history, no evidence of an eviction filing, was offered an opportunity to tour the property, and then a black female tester with a past eviction was told that the eviction filing disqualified her for a unit. After the tester then shared that the eviction filing was due to confusion about rental assistance and no judgment was ever entered, the tester was still showed she would not qualify. So what's the testing evidence there to do? Confirm the policy. How many tests do you need to confirm a policy? 1, 2, maybe 3. You don't need that many. So a second tester went forward, right? And the same thing occurred. The black female tester without a prior eviction was told that had a credit score above 600, no bankruptcies, evictions, or bank foreclosures on her record. The black female tester, we had a answer of eviction. She was told that hers would not be processed. And there was a third test as well. This time it was a white female tester with a prior eviction. And she asked whether she could apply because the eviction occurred approximately 4 years earlier. The agent answered that evictions automatically disqualify prospective renters. When she the tester further clarified, just a filing, not a judgment. The employee responded, it would depend on what shows up on her credit and backgrounds check, and that if late payment showed up on a credit report, she automatically be disqualified from applying. Not an ironclad denial at that point. So second case, what's the facially neutral policy or practice? They said it was a blanket ban that discouraged people from applying. The important part is what they used to show not only that a facially neutral policy, right? No prior eviction filing, that's facially neutral. It doesn't say it's going to impact one racial group or another racial group or one protected group, but no, it is facially neutral, right? But in application, it would have an adverse discriminatory effect or impact. But what they added here, and really important, they added a perpetuation of segregation claim, which strengthens it enormously. It said, after providing extensive history of the municipality's efforts to integrate the city beginning in the 1960s, over the last 2 decades, unfortunately, the city has seen a decline in black households by almost 13%. So the point is what? It was in a community where the percentage of the black population had consistently decreased. Actually, the city was doing everything they could to keep it integrated and integrate the city. It just didn't happen for whatever reasons. But the case was not against the city. The case was against, right, the apartment complex. So what was the net effect of their policy? It would be to do what? It's having an adverse impact on black families or black female-headed families, so that's doing what? Perpetuating segregation. So it's ironic that I think the perpetuation of segregation argument is the strongest one. But many people will miss it, right? So you get into that. That's a much easier showing than showing that a particular policy caused, this was Oak Park, Illinois, caused the racial imbalance in Oak Park, Illinois. How would you show that? How would you show that? If someone, black-headed female with a child, right, went to apply there, didn't get in, you'd have to figure out, first they go, oh, we don't have the records or whatever. They have to show where did the person ultimately live and all of that. It's very, very difficult to prove it or prove with any kind of statistical confidence, right? But with the perpetuation of segregation is a much stronger argument to make. They cited HUD's eviction report. Eviction increases the risk of relocating to a neighborhood with worse social conditions, worsening historical patterns of racial segregation. So what's the recommendation on this? Go real quick so I can go, right? Make sure what? That disparate impact gets raised. Make sure it gets used. It can be used in eviction cases. It can use not only to challenge cases resulting in discriminatory facts, but perpetuation of segregation. And it can be used to challenge overly restricted no eviction record policies. And from a housing provider standpoint, it's incumbent upon every housing provider to think about the impact of their policies. If they look at those if they adopt policies without looking at what the impact will be in terms of who is going to ultimately be able to rent or not be able to rent in those percentages, that will give rise to liability. On the last thing on resources, I've got a more full report on this with all the case sites if you want that. So you can look at the different case sites. Okay, thanks.
All right, thank you, Steve. Everybody awake out there? You guys doing good? Okay, we're bringing up Sol Kim now for a discussion about criminal background.
More? It's it's good to see all of you. It's wonderful to be here. This is actually the first time post-COVID that I'm speaking in front of actual people. And I got the nerves back. It's like I'm back in high school. I'm used to just doing this, staring at the computer with the sweatpants or shorts. It's the first time I'm putting these pants on in 5 years, and for some reason they kind of magically shrunk a little bit. It's kind of uncomfortable. Today I'll be talking a little bit about fair housing for people with criminal history. And I don't have Steve's passion or his inhuman ability to remember all the details in his head. I don't know how he does that. I'll be consulting my notes, and please forgive me if I'm struggling through this a little bit. So being a lawyer, first things first, I will is the definition. I use the term people with criminal history, and there's a few different terms that people use, including formerly incarcerated and my favorite, people who come into contact with the justice system, like some kind of a like all-destroying juggernaut that just plows through everything. And I couldn't find something that's short. I don't want to say like two-sentence phrase every time. So I use the term people with criminal history, but just be mindful that this actually affects people more than what the term suggests, because when you hear the term people with criminal history, most of people will be thinking someone who went to prison or was sentenced in some way. But in fact, when it comes to housing issues, a lot of the people who are affected are in fact people who don't have that. People who are merely arrested and never charged. Sometimes people who had the records expunged or removed, and by definition they shouldn't have criminal history. But like I think we covered this a little bit earlier today, they have the ability to do the background check and even dig out these information, and they affect people even without the charge or conviction. So just keep in mind, I'm using this as a kind of a convenient, quick term, but this covers more people than what the term seems to suggest. And sometimes, in some circumstances, it even covers the victims of crime when it comes to like abused families or abuse victims struggling to find home. So that's the very short definition part. Second part, disclaimer. I work for, I'll just go back. I'm not sure how, sorry. I work for HUD. I'm a HUD attorney, but nothing I say today is a HUD position. It's all my purely personal opinions. I noticed that my boss does not make my coworkers put this in, and she said, well, you go off script too much. So you might hear some things today, and that is purely my personal opinions and thoughts. And I know I'm preaching to the choir a little bit here, but one thing I did want to emphasize is the gravity of the subject. Sometimes we talk about housing and the news media almost like it's an accessory or something that's like a luxury, but housing is an essential need. After air, water, food, you need a house or shelter of some kind to function as a human being. To not have a house is to basically to be excluded from humanity in some ways. And I'm kind of tempted to quote Mark Twain here, who said people who are naked have very little influence in society. You could say the same thing about people who have no home or shelter. And so when we talk about people struggling to find housing, we are talking about people who are struggling to have something that's essential to function as a human being. we're not talking about luxury rights. And these are some quotes of people who recognize that fact, including the Declaration of Human Rights. I just wanted to go a little bit about the gravity of the situation. I think everybody knows we are living in an over-incarcerated society. We have some problems as a society, and this is one of the manifestations. As many as 100 million US adults, nearly 1/3 of the population, have a criminal record of some sort. This is a staggering figure. Every year, over 650,000 people are released from prison. So these are actually incarcerated persons who are coming out to the society. And formerly incarcerated people are nearly 10 times more likely to be homeless compared to the general public. So we have a situation here of a severe need to address. This is not a small problem. This problem affects a lot of Americans. And the problem is aggravated by the fact that there's this kind of a negative feedback loop between being homeless and coming into contact with the justice system, to use the expression. That picture somehow really hit me emotionally. We are putting homeless people in prison in increasing numbers, and then the people who are in prison are increasingly struggling to find housing. It's a very destructive negative feedback. The second picture is a picture from San Diego where police is raiding homeless encampment, I guess, and then arresting people who are there, probably going to get chewed up by the system. This is not in the slides, but I just wanted to emphasize that we have a very concerning trend where, according to a study, we had 1,300%, that's 13-fold growth in homeless population over 50 states. And not coincidentally, during the same period of time, over 200 cities have passed various laws making it either more difficult or illegal to be homeless or be engaged in activities that are typically associated with being homeless, such as loitering, panhandling, living in vehicles. Some places make that illegal. Over 25% of homeless people have reported that they have been arrested. So we are in a major destructive cycle that needs to be addressed. The problem is also made more serious because the impact of over-incarceration and homeless does not hit our society equally. It has a severe disparate impact on people based on their protected class. And this is an incarceration study. I don't think I need to go through the details. I don't think it's going to surprise anybody, but just to cite one, the incarceration rate of African American men was 5.6 times that of white non-Hispanic men. I think the Native Americans are even higher. There's a huge whole historical and legal reasons why Native Americans get over-incarcerated. Part of that is that they are subject to federal law, not the state law or local law, and the federal law tends to be way more severe than a state or local law because it's kind of designed with a different kind of situation in mind. But also to add that the lack of education, crippling poverty, etc. One maybe unsurprising factor is a lot of the people who are incarcerated or have been incarcerated have higher rate of mental or other disabilities, 38% compared to 15% in the general population. So when people with criminal history are subject to these struggles of finding home, it disproportionately impacts people from certain ethnic backgrounds. HUD has made some efforts to start addressing this issue. I know like 20 years ago, no one was talking about this problem. And at least the positive fact is now it's being recognized. So 2011, HUD Secretary sent an open letter to PHAs, basically telling them that they need to start giving quote-unquote second chances to people who are formerly incarcerated. 2012, HUD joins the Federal Interagency Council that gets together and tries to talk about ways to change the policies or existing regulations. 2016, HUD Office of General Counsel issues a Fair Housing Act-based guidance on when housing providers can use criminal records and how they should use it when screening applicants. And from 2016, we magically time travel to 2022 because nothing happened from 16 to 20 for reasons that I can't really remember. Well, okay, so I think I can say that the administration at the time, for them, from my purely personal observation, the rights of the formerly incarcerated was not high on their priority. Maybe the president is regretting that now, I don't know, who knows. But in 22, President Biden declares March as a second chance month. 22, HUD FHEO incorporates the 2016 OGC guidance. It's basically in a guidance that's designed to provide some rules for the investigators on what to look for in situations involving criminal records. And 2024, HUD amends PIH regulations to remove some of the roadblocks. We'll be talking about some of these regulations. So at least there's a recognition that this is a major issue now, and some small steps are being taken to address that. Ooh, no way. Okay, okay.
Just fast forward to the individualized assessment.
Okay, got it. Okay, so I think this is pretty clear background, but there are two major theories under Fair Housing Act: disparate treatment and disparate impact. Treatment is the classic discrimination. You know, when you see a movie, there's a bigoted landlord who's intentionally committing discrimination. That's the disparate treatment theory. Disparate impact, like Steve covered, covers more of a I guess it does not require intent. It's more to address policies and rules that has unreasonably disproportionate impact based on protected class. Both theories are applicable in situations where a landlord is unreasonably using criminal history to deny housing. Typical examples where disparate treatment might be in play, and I've seen most of these cases, is where housing provider conducts a background criminal check only on certain ethnic groups. I've seen that happen. I've seen where housing provider, when African American applicant walks in, they say, oh, by the way, we conduct criminal background check on all applicants, but they don't say that to the white applicants. I've had situations where they go back to the white applicant with a criminal history and they say, okay, it's not a big deal, we'll accept you, but not to certain ethnic groups. Those are intentional discrimination. You don't have to provide statistics. It's a clear case where people are being treated differently based on their protected classes. Disparate impact, I'm not going to go through this too much in terms of theory because Steve covered it a lot. I'm just going to give you a little bit of so like Steve said, it's a bit of a wild, wild west right now in terms of disparate impact theory. More cases you read, more confusing it gets, because even within the same circuit, based on which judge you get, it seems like they're applying the rule differently, and not to mention different circuits. Like Fifth Circuit has that very stringent standard that's very difficult to prove. Even in other circuits that don't employ that standard, it just seems like there's enough leeway for the judges to reach the end result that they want to reach. So it's a bit of a wild west out there in terms of like exactly what do you need to do to win these cases. I would say that disparate impact is best used in kind of situation involving large number of people, so city zoning rules, city ordinances, bank lending cases. It's very difficult to use in cases involving ma and pa housing because, like we said earlier, if someone only has 4 units that they're renting, it's very hard to come up with any kind of statistical anomaly. If you rent a place, normally people stay 2-3 years. So even if you go back 20 years, which most of the case we can't because no one keeps the records that long, it's very hard to conduct any. It's not a big enough sample. Just going to go through the history of disparate impact a little bit. Like as Steve was saying, it had some unusual history where HUD passed the regulation in 2013, and the Supreme Court basically upheld the regulation. And then in 2020, one of the last actions of the prior administration, HUD basically changed the regulation that Supreme Court said was legitimate to reduce the scope of the disparate impact theory, which was put on hold by the, Boston, Massachusetts federal court. And then 2023, HUD basically said, never mind, we go back to where things were. Again, for reasons that I can't really remember. I'm just going to skip that because Steve covered it. So as Steve said, the disparate impact theory has 3 prongs. First is some kind of evidence that the rules or regulations have disparate impact on certain protected classification. And part of why this is so challenging is because the way our society is, it's very difficult to have any kind of rules, law, regulation that does not have disparate impact. I mean, our society is very stratified, and you pass any kind of rule you can make. So I kind of personally see why courts struggle with this one, and different circuits have different threshold. I will just add a case here because we are talking criminal history that is very on point and helpful, which is a Connecticut Fair Housing Center versus CoreLogic Rental Solutions. This is a District of Connecticut case in 2020, basically where the housing provider was rejecting anyone who had any criminal history going back 99 years. And basically the court ran that through the 3 elements. It said that, the legal system has a disproportionate impact on certain ethnic groups, and by extending this restriction 99 years, you have shown that it has disparate impact on those ethnic groups, and the housing provider basically could not provide adequate justification on why they have to prohibit people going back 99 years. That seemed excessive to the court. So this is basically an ideal template for someone trying to pursue disparate impact theory in a situation involving private landlord. The way the 3 elements work is first you have to prove statistical impact, and the defendant, landlord, gets to come back and provide a justification for the policy or the rule, and then the plaintiff gets to say, provide a less discriminatory alternative. And like Steve said, the first element is the real challenge because the third element is easy to show. You can almost always say, you can do individualized assessment. The idea of individualized assessment is that you are evaluating the applicant on individual merit instead of relying on stereotype about people with criminal history. It's not a cure-all. Well, if we have time, I'll just go through some of what I think about individual assessment, but at least the idea is that you are judging someone based on his or her merit instead of putting them into a pigeonhole. Okay, wrap it up? Okay. So another theory that I haven't seen much used is a reasonable accommodation, which I'm sure all of you know. If you have a disability, you can ask the landlord to provide accommodation. If your criminal history can be attributed to mental disability or addiction, you can request the landlord to waive the rule against the criminal history as an accommodation. An example would be someone who had mental disability and committed acts of vandalism or property destruction, but is now on medication and is no longer a threat to the community. HUD issued a guidance in 2016 trying to clarify what housing providers can do or cannot do with the criminal history. It's worth taking a look. I'm just going to skip it because we don't have time. I am just going to go real quick to FCRA, Fair Credit Reporting Act, because this is something that we ran into while investigating. Basically, Fair Credit Reporting Act is a law designed to protect your credit report. The problem is when a landlord contracts a third-party company to check the applicant background, that is also covered under FCRA. Based on the statutory language of FCRA, there is an argument that landlord is not required to provide those background data to the plaintiff or even HUD. We disagree with that because it's really hard to investigate without any comparative. How can you prove you're treating, African Americans with criminal history differently than white applicant without looking at what other, background history those white applicants have? So we have just issued a subpoena. Tim, you might hear from us kind of soon. This is a new frontier. There's no case law, and hopefully this will go well. Now, finally, just a minute, a lot of states and local laws have jumped into this issue. There's two different philosophical approach. One is that the people with criminal history, those are undesirables. We want to exclude them from our community, and these are often called the crime-free ordinances. They have often very restrictive rules. Sometimes they prohibit private landlords from renting to someone with criminal history. In fact, basically the idea is to expel those people with criminal history out of their communities. We have one case where DOJ, actually I think they got it through HUD, pursued a case against the local government and prevailed. So this is definitely something that disparate impact theory is very suited for because it's a large municipality, affects a lot of people. And I guess my subtitle is obscuring that, but a fairly significant judgment. And then there's the opposite side, just housing laws. And you can take a look at the language, but the idea is to enable second chances for people with a criminal history. And I gave some example of Illinois state law, Cook County, and Minnesota. I think this is Minneapolis, actually. Sorry. So I'll take the question after. Sorry, just took too much time.
No, you're fine. Thank you so much. Oh my goodness, that was a lot, right? Okay, so obviously, we are a little behind schedule. Shocker, I know. But the closing remarks don't start until around 2:45, and it's probably going to be a few minutes after, just like all day. I promise you're going to want to hear what Becky has to say about occupancy standards. It is fabulous. She's got a lot of really good information for you. We're not going to have time to get to Q&A, obviously. So, in the Hoover app, all of these slides are present. If you want to download them, you can. If you have questions about this session, I would ask that you go ahead and drop those questions in the Hoover app, and if our panelists would be so kind as to go back on maybe later on and answer any questions that might be, related to their topic, that would be fantastic. So I'm going to turn it back over to Becky. All right, so aim that way, and then that is to advance, that's to go backwards.
Can do.
All right.
All right. Good afternoon, everyone. I know we're getting to the end of a long day of presentations. So like Valerie said, my name is Becky Nespatal. I'm an enforcement coordinator with the Fair Housing Center of West Michigan. So a lot of what my job responsibility includes is when we get a client or we have a concern about a policy that we say, oh, we think there might be a disparate impact, part of my role is to investigate to see what that actually looks like. So we can go ahead and get the slides started. And then specifically today, I'm going to be talking about disparate impact as it applies to occupancy standards. And when I say occupancy standards, what I'm specifically talking about for the protected basis is going to be families with children. As everyone else has said, this is not legal advice. Please don't talk to me about legal advice. Feel free to go to your local municipality, which is going to be the acting authority as far as occupancy policies are concerned. So when we talk about occupancy standards, what we're talking about in this context is a facially neutral rule, policy, or practice that limits the number of people living in a specific dwelling. And you'll see we've got a note up there saying that the Fair Housing Act protects against unreasonable occupancy standards. You'll see me say reasonable a lot, and we do talk about that. And it really comes down to safety whenever we're talking about a reasonable accommodation policy. I will go through things kind of quickly just to respect everyone's time. So as Val said, all of the information is in the slides on the app. You're more than welcome to take a look, and I'm more than happy to hang out for a couple minutes after the presentation. But we do also want to understand what it is we're talking about when we talk about the protected basis of familial status. And essentially, this is the quote from, or the line right from the Fair Housing Act. So understanding that a person who is under the age of 18 living with essentially an adult. And some examples of this are going to include a single individual, and it could also include someone who has partial custody of their child. It could include someone who is pregnant. It would include people who are in the process of adopting or securing legal custody. We're talking about foster families as well. They're included under familial status protections, as well as grand families. We've seen that term thrown around. There's so many intergenerational families these days, and all of those families are covered under familial status protections. So when we're talking about familial status and occupancy standards, there are questions that we ask ourselves to say, where does this disparate impact come from? So you'll see some of the questions that we have up there include, what is the actual policy that we have a problem with? Like we've been talking about all day, we have to understand where are the facts of what we're trying to argue. Who does it impact? When we say families with children, are we talking about one parent, one child? Are we talking about families with 3 kids, 4 kids, 5 kids? I do have some examples further on in the presentation, but these are the questions that we're asking ourselves. And then what do we mean when we say that it's disproportionately impacting families with children? These are the questions that we're constantly asking ourselves when we're looking at disparate impact, specifically when we're talking about occupancy standards. You will note up there also that families with children make up 33.2 million households in the United States. It's approximately 40% of all households. That's a significant number of people who have the potential of being impacted by an occupancy standard. As if we haven't talked to death about the elements of proof already, I will breeze through it just because, again, we've addressed it previously, but I will let you know that I'm going to focus in my presentation more on that first element when we're talking about the claimant presenting evidence that a policy or practice results in or could predictably result in a discriminatory effect on the basis of the protected characteristics. So again, we're identifying the policy and the protected basis, which in this case is going to be familial status. I have some great examples up here of policies that we have seen and statements that we have heard from housing providers as they relate to occupancy standards and family status. We have literally heard someone say, if you're about to have a baby, you need to move to a larger unit. We have had people claim Michigan law to say there's only 2 heartbeats per bedroom, and that's what it is, or that's their corporate policy. The lengthier one at the top is actually a bylaw from a homeowners association condominium bylaw, specifically saying that no more than 3 people can be in a 2-bedroom and no more than 4 people in a 3-bedroom plus. Regardless of the size of the unit, regardless of any of those things, which again, I'll talk about in just a minute. But these are all very real policies that have a discriminatory impact, even if they're not written intentionally with the idea of keeping families away. So specifically, and now we're getting back to reasonable again, specifically, the Fair Housing Act allows for housing providers to adhere to reasonable local, state, and federal restrictions when it comes to the maximum number of people in a dwelling unit. And you can see we've got the quote there as well. And when we talk about reasonable, you'll see a lot of these policies, a lot of these practices come out in property maintenance codes, which are directed at being able to understand how many people can safely live within a unit. If a housing provider doesn't adhere to those occupancy standards or doesn't adhere to those property maintenance codes, that's where we can see a potential for a challenge for an occupancy standard and a disparate impact against families with children. You'll see up here a handy chart. So when we talk about property maintenance codes or occupancy codes, there's actually an international property maintenance code, very handy for those wondering, that talks about the space that should be allowed for specific people in a specific dwelling. You'll see that they split it up by how many occupants are in there. They do include measurements for things like the living room, the dining room, and then you'll also see at the bottom there's a space available for the bedroom sizes based on the number of occupants in a specific dwelling. And generally, we'll see something along the lines of 70 square feet in a bedroom for a single person to live there. And then every person thereafter, we're talking about 50 square feet per person in a bedroom in order to determine how many people could safely live in that particular bedroom. Additionally, there are some great resources to understand what your local codes are going to be. IPMC, that International Property Maintenance Code, is not the only resource. Again, the slides in there should have those links for you if you'd like, but Municode as well as AmLegal can give local reference to any local codes. Again, so long as they're reasonable and keeping that justification in mind, it's not something we have a problem with. If there isn't a local occupancy code, because a lot of times local municipalities just won't have something, you'll either see that they've adopted that IPMC, that chart that we were talking about before, or if they have nothing, then we just default right to IPMC back again. Another great resource that we want to keep in mind, especially when we're asking those questions that we were talking about of whether or not a policy has a disparate impact or disproportionate impact on families with children, is the Department of Housing and Urban Development, or HUD's Keating Memorandum, or you'll hear the Keating Memo on a regular basis. And what this memo does is it helps housing providers and advocates understand that that 2-person per bedroom rule that you've seen a lot is a great place to start. It's a general rule. But it also gives owners and managers and housing providers the opportunity to adjust what that looks like based on the structure of the house itself. Because a 2-bedroom apartment and a 2-bedroom house and a 2-bedroom townhouse are all going to look very different. So when we talk about the Keating Memo and we're talking about those requirements, we're talking about the number and size of sleeping areas. We're talking about the overall size of the unit. We're talking about the age of the children. There are some requirements that you see that, like, children under the age of 2 are accounted for differently when we're talking about occupancy standards. The structure of the dwelling and other similar factors. So to assume, you know, a person or only 4 people in a 2-bedroom, that's not always going to be the case. And you can see how that quickly becomes a problem, especially for families with children. So what we do is we take all of these rules and we take all this great information and guidance that we have available to us, and we combine it with some of the statistical information that we have. We are able to use census data. We use American Community Survey information. We use local, state, and national research institutes. Having a great partnership with a local organization who's done all the research for us, I love it, I'll be honest. But what we do is we use that information to better understand what is that impact, what does that look like, and we're able to utilize it with tools such as the 4/5 rule, which I won't go into a lot of detail, but it is a tool that has been utilized especially in employment circumstances to say, is there a statistically significant reason to believe that a hiring practice has discriminatory standards, and we've seen that utilized in housing as well as the disparity ratio, which helps, again, understand it uses census data to pull together what kind of impact you can see as a disparate impact. And I'll give a quick example of disparity ratio, as we go through a couple of the examples that I wanted to talk about. So I did want to go through two specific cases that the Fair Housing Center of West Michigan has specifically been involved in. One's going to be more systemically based, meaning that there wasn't a specific client involved. And then another one where there was actually a family impacted, and they were the ones who reached out to us and said something doesn't seem right. So the first example that I want to go over is discussing a housing provider who was alleged to have a stated occupancy standard of no more than 2 people per bedroom. So again, we're seeing that blanket policy put in place. And that applied to every townhome and apartment that they owned, regardless of the unit's square footage and whether or not that unit had a den, an office, or other living feature that would allow for them to take in more people in a safe and secure way. The housing provider enforced the policy without regard to local health and property maintenance codes that state the square footage required for each occupant. So this was something that was done across the board. And we were very fortunate in this particular instance to be working with other fair housing centers. So we could actually expand the research when we're talking about those sample sizes. Like, we're not always going to be able to go for a landlord that has 4 units. A property like this, they've got 20 different properties that we can test, and in collaboration with other fair housing centers, we were able to find that the housing provider denied housing to families with children despite the apartments having ample square footage, because we were able to get floor plans, which was very helpful too. And we were able to see where people were impacted. And not only that, not only was there appropriate square footage, not only did they uphold that 2-person per bedroom rule, but many of those families and those testers that we had were denied from the entire complex because of those occupancy standards. And we're talking about thousands of units at this point. So in collaboration, the Fair Housing Center with other fair housing centers did the investigation, and in this particular case, we ended up filing an administrative complaint with HUD and led to a resolution of $207,000 as a settlement. Policy changes, which is the whole goal at the end of all of this, is making sure that we have policies in place that are not discriminating. Staff training, and then because of those efforts, we were able to open over 8,000 units from housing discrimination. Thank you. Oh, thank you. The next one I want to go over is actually where a client had called us and said, we were looking for a home. It's me, my husband, and our 4 kids. And I'm pregnant, by the way. We're looking for a place for all of us to live. We found this amazing 3-bedroom, 2-bath townhouse, that was located within a condo owners association. They had done the application, they found that they were qualified in every other way, so they were able to get a copy of the bylaws and the community rules, which specifically said that the occupancy limit for the condo is 5 people. And now this is a family of 6, soon to be 7, so they were told, no, you can't do this. Additionally, the resident agent who had been working with them steered them to another place with additional bedrooms, higher rent, different property entirely, and said, well, this kind of house can better accommodate a family of 6. And the family, they tried, they really did. They said, this doesn't seem right, can I talk to someone? I really think that there's enough room. This is a 2,000 square foot house. There's no reason why 6 people cannot live here. And the property manager ended up saying to them in an email, I love when that happens, that the size of a family is not a protected class and it is not possible to discriminate against the size of a family. That makes no sense, but you can, as it turns out. So we took on our role as the Fair Housing Center and we did some investigating of our own. So utilizing the tool of the IPMC standards, we were able to review the size of the home and found out that based on IPMC standards, the townhouse could safely house up to 9 people. So 6, 7 should not be a problem as far as safety is concerned, And then what you'll see here is we, again, utilized the tools that we had. And this particular home happened to be outside of the Grand Rapids city area in Kent County. So what we did is we're like, you know what? I wonder what households are structured like in Kent County and how families are impacted. So we were able to find that A six-person household with children as a percentage of all families with children in Kent County accounts for about 8.6% of households. And then we did the same thing for six-person households without children as a percentage of families without children, in Kent County is 0.2%. So utilizing one of those great tools that we were talking about before, in this case, the disparity ratio, we came up with the number 43, which essentially says that a family with children with this particular family size is 43 times more likely to be impacted by this policy than a family of six with no kids in Kent County. So I feel like it's fairly safe to say that there is a statistical probability that families with children might be impacted more by this particular policy. And as you can see, a family with 7 children, there are no families of 7 without children in Kent County, so 100% of those families are going to be impacted. So to wrap up, I do want to talk about some of the effective solutions that we can talk about. And there's a lot here. Again, they're all in your notes, so feel free to take a look through them as you have the opportunity. The biggest thing I'm going to say is know your codes, do your research. Understand where you live and how your policies impact where you live. That's going to be the moral of the story in all of these, I'll be honest. Ensuring that those restrictions don't contain any other discrimination. Always ask who's being left out. That's a big thing that we're always asking ourselves at our agency. Who is being left out by implementing these policies? You'll see, again, any of those definitions should be complying with the Fair Housing Law, constantly reviewing bylaws, policies, and procedures that may impact families with children at a greater rate of families without children. If you're ever looking for tools, the Fair Housing Center of West Michigan has a great one in the occupancy guidebook. I know it's my favorite. This is a step-by-step guide for housing providers. I would so much rather have a conversation with a housing provider about how can I work through this, as opposed to having to do an investigation, filing a complaint, having to go through the resolution process. So we make those tools available for you with a calculator to say how many people can safely fit in this unit. So I'm always going to encourage people to look that up. Our website has an entire page, searchable page of resources based on all the protected classes, and it includes that occupancy guidebook. If you've got more questions, ask us. I'm always happy to.
All right. Woo. Thank you. Thank you, experts. Thank you, everybody, for sticking it out with us. So where we had lunch at in the atrium, I'm being told that there are some snacks there and that there's a pretty cool thing happening at 3 o'clock in the auditorium. So that's it. That's all for Disparate Impact. Y'all have a great rest of the day. I hope you've enjoyed this conference so far.